Mr Chairman, I would also like to take the opportunity to have a closer reading of Section 5, or Clause 5 of this bill, principally because of a comment that was made by the Minister when she was in the chair, in response to a point raised by a number of us on this side, that this legislation acts retrospectively and that people will not be able to seek compensation for having been denied some of their benefit income, because and the Minister seemed to be saying in her comment that wasn't correct, that people would be able to apply retrospectively. However, I don't believe that is what Clause 5. My colleague Ruth Dyson says they can apply, but they will be turned down. That may be an accurate reading of what the Minister meant, but I just want to explore the Minister's statement looking through Clause 5. So Clause 5.1 says that the Principal Act must be read as if the amendments to Section 80BA 4A1 and B made by Section 4 of this Act had come into force on the 3rd of June 1998. In other words, this legislation acts retrospectively, and where we are to imagine that the changes made by this legislation came into force back in 1998 when the national government rushed their amendment through under urgency and stuffed this up in the first place. So that to me appears on the face of it to mean that people cannot seek retrospective compensation. However, we have Clause 5.2, which reads, however, subsection 1 does not apply in the case of any decision or determination made before the commencement of this Act. And then we have a series of subclauses. A, that affects the appellant in Social Security Appeal number SSA 001/14 and SSA 002/14 brackets 2014 NZ SSAA 39. I have no idea what that means. And that's the issue with doing these things under urgency. Here we are debating this legislation, and I have absolutely no idea at all what that clause means. And I would be grateful if the Minister or any member opposite could get up and explain that, because I have zero understanding of that clause. B, that affects the appellant in Social Security Appeal number SSA 115/14 and SSA 134/14, 2014 NZ SSAA 106. Ditto subsection A. C, that is a decision to commence a benefit on the day on which the stand down period ends. Again, I'm not sure how that will be implemented. D, that relates to the commencement of a benefit on or after 20 May 2014 and is the subject of an application for a review under Section 10A of the Principal Act made at any time within 6 weeks after the commencement of the Act. And that bit I kind of do get. The government accepts they were acting illegally for a year and a half, and they will accept applications for people who were treated in a fashion that was illegal during the period in which the government knew that it was acting in a fashion that was illegal. I get that one. E, that relates to the commencement of a benefit at any time on or after 3 June 1998 and is the subject of an application for a review under Section 10A of the Principal Act made at any time before the commencement of this Act. And I understand that one as well. I get that. It means you had to get your application in before this legislation receives royal assent, which is probably why they're pushing this through under urgency, so to reduce the opportunity for people to actually get their applications in. So I challenge what the Minister said, that people will be able to apply, although maybe Ruth Dyson is right. They can apply away to your heart's content. But the law will say you can't actually get compensation. So I understand D&E, and I don't think they operate in the fashion that the Minister led the House to believe they will operate. I have no idea what Section 5(2)A through C actually mean. And I would really appreciate a member opposite rising to their feet and actually explaining that, because we're here in the House debating legislation, attempting, Mr Chairman,
The Honourable David Cullen.